Our topic is the First Amendment's right. The First Amendment to the United States Constitution prevents the government from making laws respecting an establishment of religion, prohibiting the free exercise of religion, or abridging the freedom of speech and of the press. The freedom of assembly of the right to petition the government for redress of grievances. It was adopted on December 15, 1791 as one of the 10 amendments that Constitution, that Bill of Rights. Freedom of religion. Religious liberty, also known as freedom of religion, is the right of all persons to believe, speak, and act individually and in community with others, in private and in public, in accord with their understanding of ultimate truth. The acknowledgement of religious freedom as the first right protected in the Bill of Rights points toward the American founders' understanding of the importance of religion to human, social, and political flourishing. Freedom of religion is protected by the First Amendment through in Establishment Clause and Free Exercise Clause, which together form the religious liberty clauses of the First Amendment. The first clause prohibited any governmental establishment of religion, and the social prohibits any governmental interference with the free exercise thereof. These clauses of the First Amendment encompass the two big arenas of religion in constitutional law. Establishment case deal with the Constitution's ban on Congress endorsing, promoting, or becoming too involved with religion. Free exercise cases deal with Americans' right to practice their faith. Both clauses sometimes compete with each other. Establishment of religion. The precise meaning of the Establishment Clause can be tracked by the beginning of the 19th century. The Establishment Clause. The Establishment Clause forbids federal, state, and local laws which purpose is an establishment of religion. The term establishment denoted in general direct aid to the church by the government. The Establishment Clause acts as a double security, for its aim is as well the prevention of religious control over government as the prevention of political control over religion. To prevent this dangerous development, they set up the Establishment Clause as a line of demarcation between the functions and operations of the institutions of religion and government in society. The National Constitution Center observes that, absent some common interpretations by jurists, the precise meaning of the Establishment Clause is unclear, and that decisions by the United Supreme Court relating to the Establishment Clause often are by 5-4 votes. The Establishment Clause, however, reflects a widely held consensus that there should be no nationally established church. After the American Revolutionary War, against this background, the National Constitution Center states. Next is free exercise of religion. The acknowledgement of religious freedom as the first right protected in the Bill of Rights points toward the American founders' understanding of the importance of religion to human, social, and political flourishing. The First Amendment makes clear that it sought to protect the free exercise of religion, or what might be called free exercise equality. Freedom of religion means freedom to hold an opinion or belief, but not to take action in violation of social duties or belief, but subversive to good order. Next is free exercise clause. The free exercise clause offers a double protection, for it is a shield not only against outright prohibition with respect to the free exercise of religion, but also against penalties on the free exercise of religion and against indirect governmental coercion relying on employment division v. Smith 1990, and quoting from Church of the Lukumi Babalu A. 1993. The door of the free exercise clause stands tightly closed against any governmental regulation of religious belief as Cantwell v. Connecticut. Next slide, freedom of speech and of the press. The First Amendment broadly protects the rights of free speech and free press. Free speech means the free and public expression of opinions without censorship, interference, or restraint by the government. The term freedom of speech, embedded in the First Amendment, encompasses the decision what to say as well as what not to say. Freedom of speech and of the press attach the core rights of free speech and free press are several peripheral rights that makes these core rights more secure. The, the peripheral rights encompass not only freedom of association, including privacy in one's associations, but also, in the words of Griswold v. Connecticut, 1965, the freedom of the entire university community, the right to distribute, the right to receive, and the right to read, as well as freedom of inquiry, freedom of thought, and freedom to teach. Freedom of speech, meaning this clause ensures that individuals have the right to express themselves without government interference. It's the most basic component of freedom of expression. Scope. The Supreme Court has interpreted speech broadly, covering not only talking and writing but also broadcasting using the internet and other forms of expression. Content-based restrictions. Generally, laws that restrict speech based on its content violate the First Amendment. For example, laws prohibiting criticism of a war, opposing abortion, or advocating high taxes are considered unconstitutional. Exceptions. There are situations where the government can constitutionally restrict speech under a less demanding standard. Defamation. False statements that damage a person's reputation can lead to civil liability or criminal punishment, especially if the speaker deliberately lied or made statements they knew were likely false. Symbolic expression. The freedom of speech also applies to symbolic expression, such as displaying flags, burning crosses, or wearing armbands. Freedom of the press. The First Amendment also protects the freedom of the press, meaning it ensures that the press can operate independently without government restrictions. Scope. The press includes newspapers, magazines, online media, and other journalistic outlets. Significance. A free press plays a crucial role in information, the public, holding government accountable, and promoting transparency. Next is political speech. The ability to publicly criticize even the most prominent politicians and leaders without fear of retaliation is part of the First Amendment. Because political speech is core First Amendment speech, as the Supreme Court stated with respect to the judicial branch of the government exemplarily that the First Amendment prohibits any law abridging the freedom of speech or the press. The assumption that respect for the judiciary can be won by shielding judges from published criticism wrongly appraises the character of American public opinion. Anonymous speech. In Talley v. California, 1960, the court struck down a Los Angeles City ordinance that made it crime to distribute anonymous pamphlets. Justice Hugo Black wrote into the majority opinion. There can be no doubt that such identification requirement would be tend to restrict freedom to distribute information and thereby freedom of expression. Anonymous pamphlets, leaflets, brochures, and even books have played an important role in the progress of mankind.
Freedom of expression key issues. Advancements in information technology have revolutionized global communication, offering incredible new avenues for people to connect across the world. However, alongside these innovations come fresh responsibilities and complex ethical challenges. In this section, we delve into key issues related to freedom of expression, including controlling access to information on the Internet, anonymity on the Internet, defamation and hate speech, and pornography. Controlling access to information on the Internet. While there are compelling arguments in favor of online freedom of speech, the situation becomes complex due to children's easy access to the Internet. Even some proponents of free speech recognize the necessity of limiting children's Internet access. However, achieving this without inadvertently restricting adults' access and violating First Amendment rights poses a challenge. In response, the US government has enacted laws, and software manufacturers have developed specialized software to block objectionable content, some of which are Communications Decency Act, Child Online Protection Act, Internet Filtering, Children's Internet Protection Act, and Internet Censorship. Communications Decency Act. The Telecommunications Act became law in 1996. Its primary purpose was to allow freer competition among phone, cable, and TV companies. The act was broken into seven major sections or titles. The Communications Decency Act, or CDA, was the Title V of the Telecommunications Act, aiming at protecting children from pornography. The CDA imposed $250,000 worth of fines and prison terms of up to 2 years for the transmission of indecent material over the Internet. In February 1996, the American Civil Liberties Union and 18 other organizations filed a lawsuit challenging the criminalization of so-called indecency on the web under the Communications Decency Act. The issue with the CDA lay in its broad language and vague definition of indecency, which left the determination of standards to individual communities. In June 1997, the Supreme Court ruled that the law was unconstitutional, affirming that the Internet deserved the highest protection available under the First Amendment. The court's ruling emphasized that the interest in encouraging freedom of expression in a democratic society outweighs any theoretical but unproven benefit of censorship. This decision effectively extended the same free speech protections to online communication as those existing for print media. Had the Communications Decency Act been upheld as constitutional, it would have subjected all online content to legal scrutiny. Consequently, Many existing websites might not exist today or would have significantly altered their content. Websites that could have been labeled as indecent under the CDA would have faced substantial liability risks. Section 230 of the Communications Decency Act shields Internet service providers from liability when they publish user generated content, as long as an ISP's actions do not cross into content provider territory. They enjoy immunity. Generally, the closer an ISP is to being a pure service provider rather than a content provider, the more likely Section 230 immunity applies. This provision of the CDA has not been ruled unconstitutional and is the reason why social companies like Facebook and Twitter cannot be sued for defamation based on user postings. Child Online Protection Act. In October 1998, the Child Online Protection Act, or COPPA, was signed into law. This provision aims to protect minors from harmful content online. COPPA states that whoever knowingly and with knowledge of the character of the material in interstate or foreign commerce by means of the World Wide Web makes any communication for commercial purposes that is available to any minor, and that includes any material that is harmful to minors, shall be fined not more than $50,000, imprisoned not more than 6 months, or both. Meaning that anyone who knowingly, with awareness of the material's nature, communicates commercial content via the World Wide Web to minors, and includes harmful material, may face a fine of up to $50,000, imprisonment for up to 6 months, or both. The goal is to protect minors from harmful online content. Subsequent sections of the Act allow for penalties of up to $150,000 for each day of violation. COPPA became a focal point for advocates of free speech. It had implications not only for sellers of explicit material online and their potential customers, but also for setting standards related to Internet free speech. Supporters of COPPA, primarily the Department of Justice, argued that the act protected children from online pornography while still preserving the rights of adults. However, privacy advocacy groups, including the Electronic Privacy Information Center, the ACLU, and the Electronic Frontier Foundation, contended that the language in COPPA was overly vague and restricted adults' ability to access material protected under the First Amendment. After temporary injunctions, hearings, and appeals, the Supreme Court ruled in June 2004 in Ashcroft v. American Civil Liberties Union that enforcing COPPA would have a potential for extraordinary harm and a serious chill upon protected speech. Internet filtering. An Internet filter is software that can be used to block access to certain websites that contain material deemed inappropriate or offensive. The best Internet filters use a combination of URL filtering, keyword filtering, and dynamic content filtering. URL filtering. Specific URLs or domain names are flagged as belonging to objectionable sites. Users are then restricted from accessing these flagged URLs. Keyword filtering involves blocking websites based on specific keywords or phrases. This method aims to prevent users from accessing content related to those keywords. Dynamic filtering evaluates the content of each website immediately before displaying it to the user. Techniques such as object analysis and image recognition are used to assess the content. Internet filters are designed to block specific types of content, such as explicit material or harmful websites. However, they can sometimes be overly aggressive and block legitimate and useful content. Studies by various organizations found that filters block websites containing useful information about civil rights, health, sex, and politics, as well as online databases and online book catalogs. Several organizations opt to install filters on their employees' computers to block access to websites containing objectionable material such as pornography. In cases where employees are inadvertently exposed to such content, they may have a valid claim for sexual harassment. Additionally, implementing filters helps ensure that employees remain focused on work related websites and do not waste time on non business related websites. According to Top 10 Reviews, the top rated internet filters for home users for 2013 include NetNanny Parental Controls, McAfee Safe Eyes, and McAfee Family Protection. Safe Eyes from InternetSafety.com is internet filtering software that filters videos on YouTube, manages the viewing of online TV by choosing the age appropriate ratings. It also blocks the use of media sharing applications used to download pirated music and videos. Internet software filters have also been developed to run on mobile devices such as Android, iPhone, and Microsoft smartphones. An alternative method for restricting access to websites involves subscribing to an internet service provider that performs the blocking. In this approach, the blocking occurs at the ISP server level rather than requiring software updates on each user's individual computer. As a result, users do not need to worry about maintaining or updating their own filtering software. ClearSale or Family.net is an internet service provider proactively restricts access to websites related to serious sensitive topics. These topics include bomb making, gambling, hacking, hate, illegal drugs, pornography, profanity, public chat, satanic activities, and suicide. ClearSale's team diligently searches the web daily to identify new sites that should be added to their block list. The ISP employs several filtering mechanisms, including blocking specific URLs, known pornographic hosting services, and sites containing specific keywords. As a result, millions of web pages are effectively blocked by ClearSale's robust filtering capabilities. Additionally, news groups are also restricted due to the potential for containing pornography. Children's Internet Protection Act. Congress passed the Children's Internet Protection Act in 2000 in another attempt to protect children from accessing pornography and other explicit material online. This legislation aimed to create a safer online environment for students and library patrons by restricting their access to inappropriate material. The law mandated federally financed schools and libraries to implement technological protection measures, such as internet filters, to prevent access to obscene material, pornography, and other harmful content for minors. Congress did not specifically define what content or websites should be forbidden or what measures should be used. These decisions were left to individual school districts and library systems. Schools or libraries that did not adhere to the Children's Internet Protection Act would lose their eligibility to receive federal funding through the E-rate program. The E-rate program assists in covering the costs associated with internet connections. The following points summarize the Children's Internet Protection Act. Under the Children's Internet Protection Act, schools and libraries must meet specific requirements to qualify for discounts offered by the E-rate program. These requirements include certifying that they have implemented internet safety measures to block or filter content that is obscene, contains child pornography, or is harmful to minors, especially for computers used by minors. Schools subject to CIPA are required to adopt a policy to monitor the online activities of minors. Schools and libraries subject to CIPA are required to adopt a policy addressing access by minors to inappropriate matter online, the safety and security of minors when using email, chat rooms, and other forms of direct electronic communications, unauthorized access, including hacking and other unlawful activities by minors online, unauthorized disclosure, use, and dissemination of personal information regarding minors, and restricting minors' access to materials harmful to them. CIPA does not require the tracking of Internet use by minors or adults. Concerns raised by opponents of the Children's Internet Protection Act are power transfer to private companies. Critics worried that CIPA gave too much power to private software companies that develop Internet filters. These companies determine which sites to block, potentially affecting educational access. Unclear motives. Some filtering companies were suspected of unclear motives. For instance, some tracked students' online activities and sold the data to market research firms. Ineffectiveness of filters. Certain versions of Internet filters were ineffective, blocking legitimate sites while allowing objectionable ones to slip through. Penalties and funding. Penalties associated with CIPA could lead schools and libraries to lose federal funds from programs like E-rate. This loss would disproportionately impact students in poorer schools, limiting their access to a fully capable internet. Arguments raised by proponents of Children's Internet Protection Act are child protection. Supporters of CIPA argue that shielding children from drugs, hate, pornography, and other harmful topics justifies the use of Internet filters. Flexibility and customization. They emphasize that Internet filters are highly flexible and customizable, allowing local communities to tailor them to their specific needs. Voluntary implementation. Schools and libraries can choose whether to implement a children's internet protection program. However, opting out means they won't receive federal funding for internet access. Implementing Children's Internet Protection Act in schools. Numerous school districts have adopted programs aligned with the Children's Internet Protection Act. To ensure meaningful acceptance of an internet filtering system, it's essential to engage in discussions with parents, students, teachers, and administrators. By seeking feedback from everyone involved, the program can be refined and tailored to meet their needs. Additionally, a successful implementation requires students, parents, and employees to sign an agreement outlining the school district's acceptable use policies for accessing the internet. Controlling internet access via a central district-wide network rather than having each school set up its own filtering system reduces administrative effort and ensures consistency. Procedures must be defined to block new objectionable sites as well as remove blocks from websites that should be accessible. Implementing Children's Internet Protection Act in libraries. Implementing CIPA in libraries is much more difficult because a library's services are open to people of all ages, including adults who have First Amendment rights to access a broader range of online materials than are allowed under CIPA. At least one federal court has ruled that a local library board may not require the use of filtering software on all library computers connected to the internet. A possible compromise for public libraries with multiple computers would be to allow unrestricted internet use for adults, but to provide computers with only limited access for children. The challenge of implementing CIP in libraries. The American Civil Liberties Union filed a lawsuit challenging CIPA. In May 2002, a three-judge panel in Eastern Pennsylvania ruled that CIPA required libraries to violate the First Amendment rights of their patrons. Consequently, they deemed CIPA facially invalid under the First Amendment. The ruling instructed the government not to enforce CIPA. The Supreme Court reversal. However, in June 2003, the U.S. Supreme Court reversed this decision in the case of United States v. American Library Association. The Supreme Court held that public libraries must purchase filtering software and comply with all provisions of CIPA. The decision was reached by a 6-3 majority. Internet censorship. Internet censorship is the control or suppression of the publishing or accessing of information on the internet. Censorship can take many forms, such as limiting access to certain websites, allowing access to only some content or modified content at certain websites, rejecting the use of certain keywords in search engine searches, tracking and monitoring the internet activities of individuals, and harassing or even jailing individuals for their internet use. Here are the top 5 countries with the highest number of internet users since June 30, 2012. Internet censorship examples by country. In Brazil. In Brazil, the government's requests have led to the closure of more Google Gmail accounts and blogger sites than in any other country. Initiating a lawsuit to request the removal of internet content is relatively straightforward and cost-effective. However, this ease of legal action has had a stifling effect on Brazilian journalists and internet bloggers, as litigants can challenge content and demand the disclosure of anonymous sources. In Myanmar, dissemination of information via the internet is tightly monitored and controlled. Two high-ranking government officials were sentenced to death for emailing documents abroad. In China, the government restricts access to websites that discuss a wide range of topics deemed objectionable. These topics include references to the Dalai Lama, the Buddhist leader, any content related to the 1989 Tiananmen Square protests and crackdown, and information about the banned spiritual movement Falun Gong. Chinese websites are closely monitored by censors who actively delete objectionable content. Additionally, the government employs individuals to post comments that favor the government's stance. In Cuba, the ability to go on the internet requires special permission so that only 2% of its population is online, and when a user does get connected, it is only to a highly censored version of the internet. Egypt. Although Egypt has not set up an internet filtering system under the regime of Hosni Mubarak, it did track internet posters and arrest bloggers who made posts that were unacceptable to the Mubarak government. The government also disabled access to the internet completely for periods of time. And in the United States, many in the United States feel that US laws relating to the interception of online communications do not provide sufficient privacy guarantees for users. There are also concerns that some US companies are selling equipment and technology to the Chinese government that enable it to censor internet content for users in China.
Strategic Lawsuit Against Public Participation, or SLAPP. A strategic lawsuit against public participation is a strategy employed by corporations, government officials, and others against citizens and community groups who oppose them on matters of public interest. A slap is typically without merit and is used to intimidate critics out of fear of the cost and effort associated with a major legal battle. Many would question the ethics and legality of using a slap. Others would claim that all is fair when it comes to politics and political issues. Of course, the plaintiff is in a slap cannot present themselves to the court admitting that their intent is to censor their critics. Instead, the slap takes some other form, such as defamation lawsuit that makes claims with vague wording that enables plaintiffs to make bogus accusations without fear of perjury. The plaintiff refuses to consider any settlement and initiates an endless stream of appeals and delays in an attempt to drag the suit out and run up the legal costs. Every year, thousands of people become slap victims due to their participation in perfectly legal actions, such as phoning a public official, writing a letter to the editor of a newspaper, speaking out at a public meeting, or circulating a petition. For example, a New Jersey man recently spoke out against a proposal to build an apartment complex in his neighborhood, and soon after found himself the defendant in a $2.5 million defamation lawsuit. The plaintiff, the developer of the complex, claimed that he had suffered disgrace, humiliation, and shame throughout the community, permanent harm to his professional and personal reputations, and severe mental anguish and emotional distress. Anti-SLAPP laws are designed to reduce frivolous slaps. 26 states and the District of Columbia have put into effect anti-SLAPP legislature to protect people who are victims of a slap. While these laws vary from state to state, most are designed to quickly identify if there are any merits to the lawsuit and to keep lawyer fees to a minimum. There is no federal anti-SLAPP law as of yet. As an example of the effective use of anti-SLAPP legislation, consider the case of a California man who discovered that his business partner had opened a credit card in the name of the business at a local bank. The business went to the bank, closed the account, and informed bank employees that his partner had committed fraud. The partner sued the businessman for defamation, but the man's attorney was able to protect him by employing the state's anti-SLAPP legislation. A SLAPP is basically a lawsuit that powerful people, companies, and even the government might use to scare or silence others who speak out against them. They do this by suing them for a lot of money, even if what the person said was true or just their opinion or they're just making it up. It doesn't matter. The goal is to make them stop talking or protesting. It's like using the legal system to bully someone into being quiet. Some places have laws to stop this kind of lawsuits and protect free speech. Just like I've said in the video earlier in the report, 26 US states already employ anti-SLAPP laws.
In this chapter, I will discuss about the anonymity on the internet. Anonymous expression is the expression of opinions by people who do not reveal their identity. The freedom to express an opinion without fear of reprisal is an important right of a democratic society. Anonymity is even more important in the countries that don't allow free speech. However, in the wrong hands, anonymous communication can be used as a tool to commit illegal or unethical activities. Next, anonymous political expression. When we say anonymous political expression played an important role in the early formation of the United States. Before and during the American Revolution, patriots who dissented against British rule often used anonymous pamphlets and leaflets to express their opinions. England had a variety of laws designed to restrict anonymous political commentary, and people who found guilty of breaking these laws were subject to harsh punishment from whippings to hangings. A famous case from 1735 involved a printer named John Singer, who was prosecuted for the seditious libel because he wouldn't reveal the names of anonymous authors whose writing he published. The authors were critical of the governor of New York. The British were outraged when the jurors refused to convict Singer in what is considered a defining moment, the story of freedom of the press in the United States. In early 2000 years, Supreme Court has rendered rulings that addresses anonymity as an aspect of the Bill of Rights. One of the first rulings was in the 1958, which is Case of National Association for the Advancement of the Colored People, or what we call NAACP, Alabama, in which the court ruled the NAACP did not have to turn over its members list to the states of Alabama. Another rule is Land Bank Anonymity case involved a sailor Britain with discharge from the U.S. Navy of the information obtained from Internet Service Providers (AOL) in 1998. Following a tip, a Navy investigator asked AOL to identify the sailor who used a pseudonym to post information in an online personal profile that suggested they might be gay. What does doxing mean? Doxing involved the examination of the internet records in an attempt to reveal the identity of an anonymous poster. For example, a doxer looking to track down the identity of someone who posted in a discussion forum on one website might research for clues to the poster's identity on Facebook, Twitter, and other online sources. Some view such activity as the equivalent of a helpful neighborhood watch. Others liken the activity to an online with the potential of causing harm by the identifying incorrect parties. Here are the importance of maintaining anonymity on the internet. They might be seeking help in an online support group. Next, reporting defects about a manufacturer's goods or services. Then, taking part in a frank discussion of sensitive topics. And lastly, expressing a minority or anti-government opinion in a hostile political environment or participating in chatroom. What is Anonymous Remailer Service? It uses a computer program to strip the originating header and or IP number from the message. It then forwards the message to its intended recipients, an individual, a chat room, or a news group, with either no IP address or a bogus one. It ensures that no header information can identify the author. Some remailers route messages through multiple remailers to provide a virtually untraceable level of anonymity. John Delosu's Business Pass monitor and respond to both the public expression of opinions that might hurt their reputation and the public sharing of confidential company information. When anonymous employees revolt harmful information online, the potential for broad dissemination is enormous and it can require great effort to identify the people involved and stop them. EFF attorneys argued the court to apply the four-part test adopted by the federal courts in the Doe v. Dubart.com Inch. 35 cases to determine whether a subpoena for the identify of the web poster should be upheld. In the case, the federal court ruled that a subpoena should be enforced only when the following occurs. Number 1. The subpoena was issued in good faith and not for any improper purpose. 2. The information sought related to a core claim or defense. Number 3. The identifying information was directly and materially relevant to the claim or defense. And number 4. Adequate information was unavailable from any other source.
Hate speech. In the United States, speech that is merely annoying, critical, demeaning, or offensive enjoys protection under the First Amendment. Legal recourse is possible only when hate speech turns into their clear threats and intimidation against specific citizens. Persistent or malicious harassment aimed at a specific person is hate speech, which can be prosecuted under the law. But general, broad statements expressing hatred of an ethnic, racial, or religious group cannot. A threatening private message sent over the internet to a person, a public message displayed on a website, describing intent to commit acts of hate-motivated violence against specific individuals, and libel directed at a particular person are all actions that can be prosecuted. Although internet service providers do not have the resource to pre-screen content, and they do not assume any responsibility for content provided by others, many internet service providers do reserve the right to remove content that, in their judgment, does not meet their standards. The speed at which content may be removed depends on how quickly such content is called to the attention of the internet service provider, how egregious the content is, and the general availability of internet service provider resources to handle such issues. To post videos on YouTube, you must first create a YouTube account or a Google account and agree to abide by the site's published guidelines. The YouTube guidelines prohibit the posting of videos showing such things as pornography, animal abuse, graphic violence, predatory behavior, and drug use. The guidelines also prohibit the posting of copyrighted material, such as music, television programs, or movies, that is owned by a third party. YouTube staff members review user-provided videos on a regular basis to find any that violate the site's community guidelines. Those that violate the guidelines are removed. Certain other videos are age-restricted because of their content. Users are penalized for serious or repeated violations of the guidelines and can have their account terminated. Because such prohibitions are included in the service contract between a private internet service provider and subscribers and do not involve the federal government, they do not violate the subscriber's First Amendment rights. Of course, internet service providers' subscribers who lose an account for violating the internet service provider's regulations may resume their hate speech by simply opening a new account with some other, more permissive internet service provider. Although they may implement a speech code, public schools and universities are legally considered agents of the government and therefore must follow the First Amendment's prohibition against speech restrictions based on content or viewpoint. Corporations, private schools, and private universities, on the other hand, are not considered part of state or federal government. As a result, they may prohibit students, instructors, and other employees from engaging in offensive speech using corporate, school, or university-owned computers, networks, or email services. Most other countries do not provide constitutional protection for hate speech. For example, promoting Nazi ideology is a crime in Germany, and denying the occurrence of the Holocaust is illegal in many European countries. Authorities in Britain, Canada, Denmark, France, and Germany have charged people for crimes involving hate speech on the web. A US citizen who posts material on the web that is illegal in a foreign country can be prosecuted if he subjects himself to the jurisdiction of that country. For example, by visiting there, as long as the person remains in the United States, he is safe from prosecution because US laws do not allow a person to be extradited for engaging in an activity protected by the US Constitution, even if the activity violates the criminal laws of another country. Pornography. Many people, including some free speech advocates, believe that there is nothing illegal or wrong about purchasing adult pornographic material made by and for consenting adults. They argue that the First Amendment protects such material. On the other hand, most parents, educators, and other child advocates are concerned that children might be exposed to pornography. They are deeply troubled by its potential impact on children and fear that increasingly easy access to pornography encourages pedophiles and sexual predators. Clearly, the internet has been a boon to the pornography industry by providing fast, cheap, and convenient access to a huge array of pornography websites. Some estimates are as high as 24 million pornography sites worldwide. Access via the internet enables pornography consumers to avoid offending others or being embarrassed by others observing their purchases. There is no question that online adult pornography is big business and generates a lot of traffic. It is estimated that there are over 72 million visitors to pornographic websites monthly. Pornography purveyors are free to produce and publish whatever they want. However, if what they distribute or exhibit is judged obscene, they are subject to prosecution under the obscenity laws. The precedent set the precedent-setting Miller, California ruling on obscenity discussed earlier in the chapter predates the internet. The judges in that case ruled that contemporary community standards should be used to judge what is obscene. The judges allowed that different communities could have different norms. The key question in deciding what internet materials is obscene is whose community standards are used. Because internet content publishers cannot easily direct their content into or away from a particular geographic area. One answer to this question is that the internet content publisher must conform to the norms of the most restrictive community. However, this line of reasoning was challenged by the Third Circuit Court of Appeals in the Ashcroft American Civil Liberties Union case, which involved a challenge to the 1998 Child Online Protection Act, or COPA. The Supreme Court reversed the Circuit Court's ruling in this case, but with 5 different opinions and no clear consensus on the use of local or national community standards. In United States, Kilbride, the Ninth Circuit Court of Appeals ruled that a national community standard must be upheld in regulating obscene speech on the internet, including obscenity disseminated via email. In United States, Lethal, the Internet Circuit Court of Appeals rejected the national community standard and adopted the older local community standard. Currently, there is no clear agreement within the courts on whether local or national community standards are used or are to be used to judge obscenity. U.S. organizations must be very careful when dealing with issues relating to pornography in the workplace. By providing computers, internet access, and training in how to use those computers and the internet, companies could be seen by the law as purveyors of pornography because they have enabled employees to store pornographic material and retrieve it on a demand. A Nielsen survey on the viewing of pornography in the workplace revealed that 21 million Americans accessed porn from their work computers in March 2010 to 29% of the workforce. In addition, if an employee sees a coworker viewing porn on a workplace computer, that employee may be able to claim that the company has created a hostile work environment. Such a claim opens the organization to a sexual harassment lawsuit that can cost hundreds of thousands of dollars and tie up managers and executives in endless depositions and court appearances. Many companies believe that they have a duty to stop the viewing of pornography in the workplace, as long as they can show that they took reasonable steps and determined actions to prevent it. They have a valid defense if they become the subject of a sexual harassment lawsuit. If it can be shown that a company made only a half-hearted attempt to stop the viewing of pornography in the workplace, then the company could have trouble defending itself in court. Reasonable steps include establishing and communicating an acceptable use policy that prohibits access to pornography sites, identifying those who violate the policy, and taking disciplinary action against those who violate the policy, up to and including termination. A few companies take the opposite viewpoint, that they cannot be held liable if they don't know employees are viewing, downloading, and distributing pornography. Therefore, they believe the best approach is to ignore the problem by never investigating it, therefore ensuring that they can claim that they never knew it was happening. Many people who would consider such an approach unethical and would view management as shirking an important responsibility to provide a work environment free of sexual harassment. Employees unwittingly exposed to pornography would have a strong case for sexual harassment because they could claim that pornographic material was available in the workplace and that the company took inadequate measures to control the situation. There are numerous federal laws addressing issues relating to child pornography, including laws concerning the possession, production, distribution, or sale of pornographic images or videos that exploit or display children. Possession of child pornography is a federal offense punishable by up to 5 years in prison. The production and distribution of such materials carry harsher penalties. Decades or even life in prison is not an unusual sentence. In addition to these federal statutes, all states have enacted laws against the production and distribution of child pornography, and all but a few states have outlawed the possession of child pornography. At least 7 states have passed laws that require computer technicians to discover child pornography on clients' computers to report it to law enforcement officials. Sexting, sending sexual images, nude or semi-nude photos, or sexually explicit videos over a cell phone is a fast-growing trend among teens and young adults. According to a survey by the National Campaign to Prevent Teen and Unplanned Pregnancy, 1 in 5 teenagers has sent or posted nude or semi-nude photos of himself or herself, including 22% of teen girls, 18% of teen boys, and 11% of young teen girls aged 13 to 16.44. Now, there is even a smartphone app, Snapchat, that enables users to send messages and share videos or images that disappear after a few seconds. However, users should be aware that recipients can take screenshots of a Snapchat on their phone, and an apparent security flaw enables recipients to receive deleted videos sent via Snapchat. Increasingly, sexters are suffering the consequences of this fad. Once an image or video is sent, there is no taking it back and no telling to whom it might be forwarded. And it is not just teenagers who participated in sexting. Consider quarterback Brett Favre and U.S. Representative Anthony Weiner, who were both parties to embarrassing sexting episodes. Sexters can also face prosecution for child pornography, leading to possible years in jail and decades of registration as a sex offender. Controlling the Assault of Non-Solicited Pornography and Marketing, or CAN-SPAM Act. The Controlling the Assault of Non-Solicited Pornography and Marketing Act 2003 specifies requirements that commercial emailers must follow when sending messages that have a primary purpose to advertise or promote a commercial product or service. The key requirements of the law include the from and to fields in the email, as well as the originating domain name and email address, must be accurate and identify the person who initiated the email. The subject line of the email cannot mislead the recipient as to the contents or subject matter of the message. In addition, if the message contains sexually oriented material, the phrase sexually explicit must appear in capital letters as the first characters in the subject line. The email must be identified as an advertisement and include a valid physical postal address from sender. The emailer must provide a return email address or some other internet-based response procedure to enable the recipient to request no future emails, and the emailer must honor such requests to opt out. The emailer has 10 days to honor the opt out request. Additional rules prohibit the harvesting of email addresses from websites, using automated methods to register multiple email accounts, or relaying email through another computer without the owner's permission. Messages whose primary purpose is to communicate information about a specific transaction or relationship between the sender and the recipient are not subject to CAN-SPAM Act. Thus, a message regarding an attempt to deliver a legitimately placed online order or information about a product recall would be exempt. Each violation of the provisions of the CAN-SPAM Act can result in a fine of up to $250 for each unsolicited email, and fines can be tripled in certain cases. A Canadian spammer was ordered to pay $173 million in fines for allegedly spamming Facebook accounts with over 4 million posts. Of course, the spammer was unable to pay the fine and instead declared bankruptcy. The Federal Trade Commission is charged with enforcing the CAN-SPAM Act, and the agency maintains a consumer complaint database relating to the law. Consumers can submit complaints online at www.ftc.gov or forward email to the FTC at spam@use.gov. Other countries have their own version of the CAN-SPAM Act. The United Kingdom recently fined two people 440,000 euros or pounds, I guess, for sending out as many as 800,000 spam text messages per day to cell phone users on behalf of claims management companies looking for accident victims to pass on to lawyers. The CAN-SPAM Act can also be used in the fight against the dissemination of pornography. For example, two men were indicted by an Arizona grand jury for violating the CAN-SPAM Act by sending massive amounts of unsolicited email advertising pornographic websites. They had amassed an email database of 43 million people and used it to send emails containing pornographic images. AOL stated it received over 660,000 complaints from people who received spam from the two, whose operation was highly profitable, enabling the two men to earn over $1.4 million in 2003. The defendants ran afoul of the CAN-SPAM Act by sending messages with false return addresses and for using domain names registered using false information. They were convicted of multiple counts of spamming and criminal conspiracy. which carry a maximum sentence of 5 years each plus a fine of $500,000 and up to 20 years for money laundering. This is believed to be the first conviction involving CAN-SPAM Act violations. There is considerable debate over whether the CAN-SPAM Act has helped control the growth of spam. After all, the Act clearly defines the conditions under which the sending of spam is illegal, and as long as mass emailers meet these requirements, they cannot be prosecuted. Some suggest that the Act could be improvised by penalizing the companies that use spam to advertise, as well as ISPs who support the spammers.